So, in the courtroom, we have Mr. Harris, we have Mr. Brown as with his attorney, and looks like we're ready to proceed. There were some declarations filed as late as yesterday. Mr. Harris's declaration was filed. So I reviewed everything that's been filed. Are we ready to proceed? Let's start there.
Yes, Your Honor.
Okay, and Mr. Harris, are you still requesting a protection?
Yes, Your Honor.
Okay. And Mr. Huber, I assume that you are opposing that request?
Correct, Your Honor.
Okay. Well, the way we tend to proceed on these matters, each side gets about 10 minutes. Typically in this situation, just arguing regarding what's already been filed. You are allowed to produce or present some additional evidence if necessary, but it's relatively limited, not intending to take testimony from a series of witnesses or something like that. So with that, I will turn it over to Mr. Harris.
Thank you, Your Honor. My name is Joseph Harris. I am the father of Ada and Janet Harris, and I am petitioning the court to grant a permanent restraining order against Dan Brown with the same restrictions that are listed in the temporary order. This petition is based on a pattern of boundary violating behaviors by a 51-year-old male, church leader and family friend towards my 17-year-old daughter and her 13-year-old sister. Over several weeks, the respondent repeatedly, privately contacted my daughter, paid for multiple gifts, and wandered around our home without permission. These actions caused fear and substantial emotional distress to my two minor daughters. RCW 7.105 protects against these very behaviors. Your Honor, you have read the petition. You read Ada's declaration. I won't repeat that at this time. But at no point did the respondent, Dan Brown, contact me or my wife asking permission to contact my daughter. He never talked about the invitations that he made to her. He never talked about the texts that he sent to her. He never asked us permission to leave gifts for her. Mr. Brown has completed our church's youth protection training program multiple times. He knowingly violated those rules. He texted my daughter one-on-one. In fact, he apologizes. He realized what he did was wrong. He apologizes in his declaration. Through his repeated contact, texts, isolating her, giving her gifts, anonymous gifts, making invitations to play online games alone, while hiding it from his family and hiding that from her family. He violated her personal space. I asked the court to grant this protection order to protect my daughter's physical safety and emotional well-being. They are young, they are innocent, they should not be worrying about a grown man incessantly contacting them, leaving gifts for them, harassing them, or hurting them. But they do worry about that, as Ada's testified in her declaration and as I have observed firsthand as a parent. And the worry is, they do worry about that, and they worry about that because of Dan Brown's course of conduct. His deliberate and repeated conduct was such that it created fear in them. He should have known that his behavior would cause alarm, fear, and substantial emotional distress. But we are here today because of his actions and his actions alone. Your Honor, I close at this time, and I'll reserve any comments to respond to anything else that comes up. Thank you.
Mr. Huber.
Thank you, Your Honor. So I'm here today representing Jonathan Daniel Brown. Goes by Dan, so I'll call him. First, procedurally, I want to clarify. The petitioner marked this as a sexual assault protection order in his petition, but there's no allegation of sexual assault included in this. The petition itself says that the person needs protection from someone who, quote, committed sexual assault, and RCW 7105 225 1B requires for a sexual assault protection order, they find the petitioner has been subjected to non-consensual sexual conduct, non-consensual sexual penetration, or commercial sexual exploitation by the respondent. Now, there's no allegations in the petition or supporting documents that remotely fit non-consensual sexual penetration or commercial sexual exploitation. And sexual sexual conduct, while it's a lot more broad under RCW 7105.010 section B3, even then, none of those definitions of various types of sexual conduct fit what's alleged here. It would seem likely the petitioner misunderstood the purpose of that box, and while they want to assign some sort of sexual motivation to Dan's actions, that's not what a sexual self-protection order is for. It seems the court may have noticed this as well in the temporary order, prohibition of stalking protection order, not a sexual assault protection order. But even so, we would ask now that if the court finds a full protection order necessary, that it would be either stalking or anti-harassment, since that's what the allegations actually are, not a sexual assault protection order. We don't believe that a protection order is justified in the first place, but we understand this court may feel differently. Additionally, we would also ask that any such order be limited in time if one is entered. The petitioner requests a permanent protection order, and such an order would restrain Dan from his family's church forever, including going to family members' weddings, funerals, and so on. His mother-in-law, for example, is not going to live forever, and we have a permanent protection order to keep him from attending her funeral. We would request that any order, if entered, again, we don't believe what's necessary, but I'm talking about procedural stuff here first, be limited to just a few years. I would say less than 5 years would be appropriate, because that would allow the petitioner's daughters to finish high school, move away. And additionally, related to this is the location restrictions also. Dan's daughter Jillian goes to the same school the petitioner's children does, meaning he'll miss her graduation, her extracurriculars, and so on. So we would request that the school be left out in the final order to if one is entered. Now, going into the substance of the case for why a protection order isn't justified, Dan's conduct wasn't intended to harass or stalk the petitioner or his family, and the petitioner or his family should not have perceived these acts as harassing or stalking. Dan's an involved youth group leader in his church, and has communicated with multiple teens as a way to get them further involved in the church community. There was no illicit or unlawful intent behind his messages or communications, and at no point is there any attempt at creating an inappropriate relationship. Dan has unpacked the various events the petitioner references in his petition, in his declaration, and explains why they are not the way they're being described. He's apologetic about the level of distress that they caused the petitioner's family. Critically, Dan had no idea it was causing distress on any level, because the petitioner's child kept engaging with him in those text messages on a friendly and open way. And further, the distress isn't really reasonable. As shown by the declaration of Shaylee Wadsworth, the petitioner's daughters had this persistent fear of being kidnapped, just based on being afraid of being kidnapped. Her distress around Dan stems from this lifelong fear, not because Dan's doing anything that remotely suggests kidnapping, assault, or anything else is imminent. And his other supporting declarations from his daughters make it clear too. Dan's simply an open, welcoming person who tries to bring in people of all ages, in church or otherwise. One describes Dan as being friendly with her college roommate, and how he brought them things like food or medication. Another daughter describes the positive relationship Dan appeared to have with the petitioner, at least until the petition was filed. And still another describes how Dan helped a new to the area family and included them in local activities. Dan's attempts at including the petitioner's daughter, making her feel welcome and appreciated in the church community, were clearly, in hindsight, misguided. He had no idea that his friendliness would be taken in the way that it was. Again, he had no idea that the petitioner's daughter had this significant fear of kidnapping, or that she was receiving his messages in the way that she was receiving them. As has been discussed by the petitioner's daughters, they were regularly in contact with adults at their church, similarly to how Dan interacted with the petitioner's daughter. We'd ask that this court deny a full protection order. There's no preponderance of the evidence to support the petitioner or his family having a reasonable fear of Dan Brown. Dan now knows how they really feel about him, and is sorry his messages were perceived in the way that they were. Doesn't plan to have any interactions with the Harris family ever again. He's been going to a different church ever since that temporary order was entered. I'd hope from his declarations and from today, it's clear all this is a matter of misunderstood sentiments. Does the court have any questions for me or my client?
Okay, Mr. Brown's daughter goes to the same school, the middle school or the high school?
The high school, I believe.
Okay. How old is she?
18-year-old ones? Yeah, 18.
Okay. So she's the same grade as, okay, that's all the questions I have at this time.
All right, thank you, Your Honor.
Mr. Harris, any response?
Thank you, Your Honor. And just to clarify on a procedural grounds, we are asking for a protection order under the stalking statute. Thank you. And we can read in RCW 9A 46.110. A couple items that are not defenses to stalking. One is that it's not a defense that there was no notice or actual notice that the person did not want the stalking behavior or the stalking party to contact them. And then furthermore, it's not a defense that they did not intend to have their actions intimidate or frighten a person. Ada has had occasional fears around bedtime of being kidnapped. It's something she's mentioned a couple times over the years. They're anxious thoughts that a daughter's had. What Mr. Brown changed was that instead of having fears that could easily be said, hey, you know, this is something you don't need to worry about. Now they're valid. She is now worried that he's going to be there, that he's going to have because he has crossed boundaries with her. She's worried that he's going to continue to cross boundaries and cross even more boundaries. He has trouble recognizing good boundaries. And she's worried that he will continue to cross boundaries, which those boundaries, if he's unable to control his boundaries, those could be physical harm, including hurting her or kidnapping her. So his actions became a constant, focused reality to her.
Let me ask a question regarding these exceptions. He's asking for, you know, special events, whatever, marriages, funerals, things like that. Do you contemplate any exception?
Respondent's mom is a member of my congregation. We attend the same church. I guess if she passes, as he alluded to, that she would pass in our congregation. And that would prevent, if her funeral was held in our building, which there's other buildings that it could be held in, but that could certainly be an issue if she passed in a certain period of time.
If the court were to, I mean, obviously the church or any other organization can exclude people from its grounds whenever it wants. I don't know that there needs to be a protection order. You know, for example, if the congregation of the church says, first of all, you're not allowed to lead youth group, one, church has the authority to do that, or to say, you can't come to this particular church at these, I mean, the church has inherent authority to do that. Is that, one, have actions like that already been taken by the church? And two, is that something that the church would, I guess, be active in regardless of what happens today? Would the church take some of those actions anyway? Or is the church leaders waiting to see what I decide?
So I have spoken with church leaders. I don't know what has been communicated with Dan Brown. He perhaps could respond on what's been communicated with him. They are waiting. I've been told that they are waiting to see how this proceeds in any criminal investigations before they make their judgments. But they told me that he was not. He has been released from his leadership role. He's no longer serving in that capacity, so he doesn't have any interactions with the youth. And my understanding is he's been told that he's not to be in that building, worship in that building in Moscow where we normally worship. But my daughters will be in that building every Sunday and Wednesday. They will be in the Pullman building Tuesday through Friday. And the purpose of that protection order is they don't have to fear of running into the respondent when they're in those buildings. But there are other buildings. There's a building in Colfax. There's other buildings in Moscow. There's locations for him to worship. Normally you worship in a boundary. We call them wards. So your ward would meet at a certain location. Where he lives in the county, it falls under the boundary of my ward, and then we meet in one of the Moscow buildings. But there are other opportunities for him to worship. So I'm not preventing him from worshiping. I'm preventing him. His actions will have resulted in him not being able to participate in worship services where my daughters are present, Your Honor.
Mentions his daughter is also in high school. They participate in any of the same activities.
The only activity they may participate in is a seminary early morning Bible study class, and then Sunday school classes on Sunday together. But as far as school activities, I'm not aware of any school activities that they would participate there together.
Okay, I think that's all the questions I have at this time. Unless you have anything else? Anything further, Mr. Huber?
Yeah, just briefly, Your Honor, I just want to highlight, I'm sure this court was aware, but the defenses to stalking that the petitioner cites, those come from the criminal code. They're not applicable in a civil protection order. Wanted to highlight that. I also wanted to just reiterate a couple of key points from my client's declaration. He discusses having recruited several children to help out with a cleaning event. I think it was cleaning up the woods or the trail near his house. There was a project working with sister missionaries. There was an invitation for those same kids who worked so hard to enjoy a movie at his house while he was gone. Again, nowhere around. There's various youth that he's involving in these activities, trying to bring into the church, trying to work with. Again, the invitation to the football game, as you saw in the declaration, there's no isolation of the petitioner's daughter here. There's no focus on her in particular. It's as I said earlier, it's a case of misunderstood sentiments. Dan was trying his best to include the youth in what's going on at the church, and include the youth and make them feel a part of the community. And as he said in his declaration, he's sorry if this one youth felt targeted or harassed, but that wasn't the intent. And we don't believe it should have been perceived that way, especially in light of how other kids were included as well. Thank you, Your Honor.
Thank you. Well, this was filed initially as a sexual assault protection order, but the court has inherent authority to change if a more appropriate protection order would be appropriate to issue that the appropriate type of order. So that's what the court did as far as a temporary order. Stalking under RCW 7105 does include the definition as far as the criminal code, but it also goes on. Stalking means any of the following: the criminal definition, cyber harassment, or any course of conduct involving repeated or continuing contacts, attempts to contact, monitoring, tracking, surveillance, keeping under observation, disrupting activities in a harassing manner, or following of another person that, one, would cause a reasonable person to feel intimidated, frightened, under duress, significantly disrupted or threatened, and that actually causes such a feeling. Two, serves no lawful purpose. And three, the respondent knows, or reasonably should know, threatens, frightens, or intimidates the person, even if the respondent did not intend to intimidate, frighten, or threaten the person. We have several facts. It's alleged, and really all of this is, facts are largely undisputed. It's Mr. Brown just argues intent, says, well, this wasn't my intent. Well, I just read the statute. Mr. Brown's intention really is not relevant. Well, it could be relevant, but it's not required. Everything here is captured through text. As Mr. Harris says, none of these text communications were approved by the Harris parents. Mr. Brown is 51 years old, texting a 17-year-old girl. Some of these communications individually would be potentially benign, although I guess it kind of depends on the actual relationship and what's expected in these youth leadership relationships. But there's quite a number of texts between a 51-year-old and a 17-year-old that I think most people would find unusual, in particular not communicating with parents about this. And of course, grooming behavior appears benign to begin with. That's how it usually goes. I don't know Mr. Brown's intentions, but let's go through these text messages. He starts off inviting 17-year-old Ada to do this project at his house, and it's true, there was a project, there's a legitimate project. Other people were invited. But again, we're going on a number of texts. Afterward, it asks her and some other friends if they'd like to watch a movie, and you guys can, he's not there, Mr. Brown's not there, but you guys can watch a movie. Send pictures. Again, the level of familiarity with a 17-year-old who is not your daughter is extremely concerning. But again, maybe just misguided sentiments, misunderstood sentiments from Mr. Brown, just trying to include the youth. And he again focuses on this one individual, Ada, and asks if she'd like to go to a football game. Sure, included other youth. And that request goes to this. They eventually go to this football game, and an awkward, I don't know, it's just an awkward interaction to me, that I would go to a football game with a 17-year-old who's not my daughter, but I guess he's a youth leader, so under that guise, he wants to call these interactions okay. Later that week or that evening, first of all, asks Mr. Harris if they'd like to have dinner. When they don't respond within 30 minutes, he texts Ada Harris, would you like to go, are you guys, what are your dinner plans? What are your family's dinner plans? Are you guys coming? I'm trying to arrange something. They haven't responded. And then he texts her some sort of game, asks her if she'd like to play a game, an electronic game, and she's doesn't really respond, or at least from the text messages that I've received. Texts her a second game. Again, this is where I don't know, we have this argument that, well, he was just including other children, including the youth, trying to be inclusive. I have no evidence that he was texting any other youth games to play. If he would, that would be, again, odd. Mr. Brown responds in his declaration that it was dumb to have done so. It was dumb to have done so. I don't know that there's any other explanation here. And I think I may have skipped over, or maybe that comes a little bit later, this incident of leaving a candy bar in her car after a track meet or a cross-country meet. He sees the Harris parents at there. Apparently he's walking around with these candy bars. He has some intention of giving these candy bars to the kids. Saw the Harris parents, didn't say anything to them, didn't say, hey, is it okay if I give Ada a candy bar, if I leave one in her car, whatever. Didn't say anything about that to them. Leaves a candy bar in her car. He also apparently leaves one for some other male, but that's pretty odd. Again, 51-year-old leaving a candy bar for a 17-year-old girl. Let's go back to this definition of stalking. Course of conduct involving repeated or continuing contacts, etc., that would cause a reasonable person to feel frightened, that serves no lawful purpose, and the respondent knows or reasonably should know that these contacts threaten, frighten, intimidate a person. If Mr. Brown's response is, well, I just didn't know, I don't know which is worse, that Mr. Brown did this intentionally or that he is unaware of how these actions would make another person feel. I haven't even got to this other incident where he They have a dinner at the Harris house. This was arranged ahead of time. Mr. Brown was walking around the Harris house without really permission, letting himself into the house, even though the event's outside, obviously looking for Ada Harris because he later texts her, "Hey, you were MIA." Again, leaves a candy bar, hides it somewhere, texts her a series of poetry clues to find this candy bar that he's left in the house. If that's not the definition of a person reasonably should know that these actions are threatening, frightening, intimidating, if Mr. Brown's judgment is so skewed that he can't recognize how this would make a person feel, that it would make the parents feel, not just the children, but the parents, walking around their house, leaving a series of clues. And Mr. Harris's declaration said there were 16 texts or something like that. I think I only received 9, but maybe that's all there was. But again, a series of poetry clues. And let's go through this again. Mr. Brown texts Ada Harris the first couple of clues in poetry. She says, "Oh, I found this candy bar." And he says, "Oh, you found it. I haven't even given you all the clues." He sends her more clues after it's already been found. In other words, he's already pre-planned out these clues in his head in poetry. Mr. Brown's response is, "Well, Mr. Harris should have talked to me about this. He should have talked to me. Come on. He's supposed to talk to the person who is stalking his 17-year-old daughter. No. And like I said, if Mr. Brown truly didn't know that this was threatening, frightening, harassing behavior, then Mr. Brown should not be a youth leader, at the least. This is extremely, looking at it favorably to Mr. Brown, it's extremely bad judgment. So the only concerns I have, frankly, absolutely, I'm entering a protection order, is the duration, whether there should be exceptions for certain church buildings. What I'm going to do is this. I'm going to enter the order for 5 years. Mr. Harris, or either of the children, the way the law reads now is essentially if a child ages out, they can request on their own reissuance of the protection order. Certainly Mr. Harris can. So the protection order will be for 5 years. At the end of those 5 years, any of Mr. Harris, Ada or Janet could ask for reissuance. If no reissuance is requested, it would terminate. As far as some sort of exception, of course, I would note that this protection order is just concerning the minors. Mr. Harris did not include himself as a protected party. I'll write some sort of, if there is a specific exception, we're talking usually, I'm thinking of for a funeral or a marriage or something like that, that Mr. Harris gives, I guess it'd have to be all 3 of them really, give written acknowledgement of an exception for that particular occasion. That would be the only exception that would be allowed. But typically I imagine, I'm not requiring, but I imagine that communication would go through some sort of church leadership. And that's really the only exception I'm allowing here. I'm not going to allow an exception for school-related activities. Again, Mr. Brown's judgment regarding what is appropriate with minors is so off base that I don't think he should be attending school activities where there are multiple youth around. So really the only exceptions that I can think of would be specific church related activities such as a funeral or a wedding, but I'm not limiting it to that. So give me a second to fill this out.
Your Honor,
Yes,
clarifying question. The school-related activities you mentioned, does this include graduation?
it does. My understanding, graduation is typically streamed. Mr. Brown's actions have resulted in these, he's brought these conditions upon himself, so it does include graduation. I mean, he's got to stay 1,000 feet away from Ada Harris, who's going to be graduating anyway, so I'm not granting an exception. All right, I've signed this order. Mr. Brown, if you come up, sign that you have received a copy of the order, we'll get you a copy. Mr. Harris, you're obviously welcome to get a copy at the end of the hearing as well. That does include the surrender of firearms order. I know Mr. Brown has already signed a declaration of non-surrender. He doesn't need to file a separate one. So, if there's nothing further, that will conclude this hearing.
Thank you, Your Honor.
Thank you, Your Honor.
All right, that brings us to the Eleanor Scott and Jonathan Scott matter. 2025-2-328-38. Mr. Haynes is present in court with his client. Ms. Grunmeyer is appearing by Zoom, and Mr. Scott is present in the courtroom. This comes on for Eleanor Scott's protection for domestic violence protection order against Mr. Jonathan Scott. There were some declarations filed yesterday. I've reviewed those. Those were the declarations of Eleanor Scott and Mr. Hibschman. So I've reviewed those. Are we ready to proceed? Ms. Grunmeyer, has everybody received all the declarations?
Yes,
That
we
were
have.
filed as late as yesterday?